Representative Walsh, after months of negotiations, a Hirst water rights compromise was found. Is this a win for the state, and why or why not?
Yes, I believe that the Hirst fix is a win for the state. The decision out of the state Supreme Court, that we know as the Hirst decision, really created a mess out of water law as it had been practiced in the state for decades. What we were able to do in the Hirst fix bill to the Hirst decision was come up with a system which leaves much of the state where it was pre-Hirst. And the important elements of this, to my mind, is that we protected residential wells. The wells that we drill, not for agricultural, industrial purposes, but just for building homes. So if you own some property, you're off the grid of a city water system and you want to put a house up, you can drill a well to provide water for the house and the house's septic and the rest of it with relatively little difficulty. We went back to that. That was before Hirst, the way it had been in the state. We went back to that. So in most of the state, and certainly most of the parts of District 19 that I represent, a residential well requires a relatively modest fee, in this case $500, and for that you get the ability to drill a well that can pull as much as 5,000 gallons a day for residential use. And that was the way it was before the Hirst decision, so we were able to protect that. There are other sections of the state, though, where more rigid and stricter water use requirements apply. In some of those areas, instead of being able to use 5,000 gallons of water today, you can use 3,000. That's still pretty good, and it covers most uses for residential water and a residential well. In a few locations, there's an even stricter standard, 950 gallons a day. That's not great, it's stricter, but it's still pretty good. And in those areas, water is already tight, water use is already tight, so it was a reasonable compromise solution for residential wells. It's all pretty good. I mean, the terms that were being discussed in the immediate aftermath of the state Supreme Court decision were much more draconian than those. There was talk of the fee to drill a well being $1,500 and the gallons per day limit to be 350 gallons. So we were able to negotiate a much better solution than that. And as I say, mostly gets us back to where we were before the Hirst decision. Most importantly, we have clarity so that property owners and local jurisdictions, counties and cities, and lenders who finance construction on homes can know with some certitude what wells will be permitted, what wells will be allowed, and the terms under which those wells can be used. So that certainty is of critical importance, because it was the chaos and the uncertainty right after the state Supreme Court decision that was really jamming up the kind of home building that we'd like to see in the state. So it was a win for the state. I've got a couple of concerns about the bill still, even though I was a yes on it. There are a couple of what they call pilot programs for metered wells. Now, I am adamantly opposed to metered wells. I'm glad that the pilot program is very limited to two specific areas. We're going to have to be watchful to make sure, frankly, that the pilot program doesn't expand anywhere else. There's no pilot program and there's no metered wells anywhere in my district or the areas around my district, so I can live with what we have there. There's some language in the statute that allows, in the case of a lack of consensus in certain watershed area working groups, allows the Department of Ecology to get back into some rulemaking for those watershed areas. And I don't like to see the Department of Ecology in a rulemaking capacity. I think that's something that should really reside with local jurisdictions, the local watershed authority. In my opinion, the Department of Ecology in this state should be basically a sort of research branch that does good scientific research and provides that information to local governments and local jurisdictions who make rules based on the information. And I'd like to, in many fronts, the Department of Ecology has crept out of that research role and tried to get into more regulation. And I'd like to see that department reined in and really concentrated on research and providing good data.
Where do you think this is going from here? Will there be legislation next year in terms of water rights issues?
There may be some fine-tuning that needs to be done with the law. That may have to do with some of those areas that are more restricted use, the 950 gallons a day areas. And there are a couple of other areas of the state that already had very specific water use rules in place. What the Hirst fix did was it allowed those local programs to stay in place. Now, some of those local programs are problematic and need to be resolved. So there may be some fine-tuning on a couple of very specific uses. But I think all in all, the compromise deal was pretty good, and I think it does give us that certainty. And I should add, too, a question I get a lot from my constituents: wells that already are drilled and are already existent are grandfathered in their traditional uses. So there's no change to the well that you have if you already have a well. I know a lot of the people in my district who are living on residential wells were concerned that there'd be some sort of clawback. There's not. If you have a well already, you can keep your well and keep using it. The new rules are for new wells being drilled going forward.